Hello, everybody.
While we're waiting for them to trade out, Mr. Pope is here. Can we address his client who was not transported?
Yes, Your Honor. The next case is Miss Sandra Fletcher, cause number 37478. Miss Fletcher was not transported, but the matter was on for a review hearing.
Right. So this matter was originally scheduled for review back in March, and it was canceled because Mr. Pope had indicated he was going to speak with his client because it was a deferred sentence. We needed her to either pay the amount, do the community service hours, or it would be on for hearing for revocation of the deferred sentence. So it was canceled with the idea that Mr. Pope was going to speak with her and that would be taken care of. It was not. So we noted the matter for hearing. Give me just a moment to get to the right place here. We noted the matter for hearing on, get to the right location. So we noted it for hearing on July 3rd, on the July 3rd, because we wanted to set it before the end of jurisdiction to allow her the opportunity to provide proof so that she could have the benefit of the deferred sentence. Prosecutor was here, but defendant was not here, nor was defense counsel. Because it's a deferred sentence, we can't just revoke the deferred if no one is here. And so we had to issue a warrant for her arrest. There was no, as far as I can understand, there was no communication with either the prosecutor or the court with regard to why no one appeared at that hearing. Warrant issued and Miss Fletcher was picked up on the warrant. So we're now here. She was not transported. City's position.
Your Honor, at this time, the city is requesting to maintain bail and $5,000 and address the deferred sentence when Miss Fletcher will be transported.
Why do you want me to hold her on bail in this situation?
The city believes that it would be sufficient to have Miss Fletcher present potentially on the next morning jail calendar, and we would address that when it at that time.
Is the city going to be asking that I impose jail time?
The city is not going to request to impose jail time, but due to the nature of the docket and what was just disclosed, the city is requesting to maintain that and move it over one day.
Mr. Pope.
Well, Your Honor, I think, first of all, the issue back in 2023, this was March of 2023, not March of 2024, was whether Ms. Fletcher had violated the conditions of her sentence. There had been, I dealt with that. There'd been, it's not relevant to this, but just some background. The city had gotten some evidence, some photos, alleged photos from a neighbor of hers that didn't like her, of her having cats in her house. And
Mr. Pope, we are not retrying this case.
I understand.
You and your client entered into a deferred, a plea with a deferred sentence. That's where we are at this time.
Right.
The question is, nobody appeared and a warrant issued for her arrest. Why should I or should I not keep her in custody to address the fact that she did not comply with the conditions of my sentence?
Well, Your Honor, I just wanted to say that the thing back in March of 2023 was not about the financial conditions. As far as everything goes, I got an email from your clerk yesterday. That's the first notice that I've actually received about this. Supposedly they had mailed me notices. They also claimed that they mailed notice to Miss Fletcher. I mean, I wanted to talk to Miss Fletcher this morning. I've talked to her family members. I mean, it's sort of, I guess, people with disabilities that are homeless, that have mental health issues, that don't pay their fines. Probably we get a different treatment in Bothell, a harsher treatment than we might somewhere else. But this is like news to me. If I had been told, if somebody had sent me something saying that the fine hadn't been paid, I would have probably gone and taken $300 out of my own pocket and paid it. It would have been a lot easier for me than this.
And then you would be facing issues with the Bar Association with regard to ethics. So I don't think that you really want to put that on the record, Mr. Pope.
Okay,
I think
but
what
you know,
we are talking
basically,
about here is a situation where you and your client agreed to conditions, and now you apparently think that those conditions don't need to be complied with, is what I'm hearing from you.
well, I mean, it's sort of, you know,
When I sentence someone and I say there's a fine or you can do community service and they say they can do it, if they tell me they can't do it, then we can discuss it. But at this point in time, we are not back at the sentencing point. We are at the point of whether or not your client has complied and whether or not I should hold her in custody to hold this hearing, because I'm not holding the hearing in her absence either. Okay?
obviously not,
What
Your
we are
Honor. I
at is
mean,
whether or not I should hold her in custody, or will she appear if I set this to an out of custody hearing? That's where we are right now, Mr. Pope.
well, I'm quite concerned because you've sent her to the sheriff's office under the contract the city of Bothell has, and they've not produced her for this hearing. I don't know what the situation is. I'm going to be
Mr.
inquiring.
Pope, we are not discussing any of that. We are talking about whether or not she needs to be held to appear. Will she appear if I release her?
I believe she will appear, Your Honor. I mean, this was a surprise to everybody, and that this happened. She was extremely surprised. I talked to her friends that were present when the Edmonds police arrested her. At least I got that background information. I got a bunch of other background information that I haven't had the benefit of discussing with my client, but
Which is
she was
why we need to set this over for hearing, and I'm not going to have the entire hearing right now. I want you to keep your comments directed and pointed to, should I release her or should I not? Are
You should
you
be-
in good communication with your client?
Yes, I'm in good communication with her, and I have
So
I
if
have her.
if I release her, you will be able to ensure that she knows of the date and can appear for her out of custody hearing. Is that what
Yeah,
I'm hearing?
yeah, and I have her like longtime partner
Okay,
here with me.
that's all I need to know is that you can confirm that she will appear, that you are in
Yes.
good communication. Good Lord. All right. I don't have an order in the file, Ms. Tatavision. Why do I not have an order in O Courts for Ms. Fletcher?
Your Honor, I am not sure. Let me get in contact with my supervisor and I will have them add the form. One moment, please. Your Honor, I have notified my supervisor and my supervisor is going to take care of that right now.
Since that has not happened, I'm going to take a brief recess while we wait for that order to be uploaded. Okay, we are back on the record on the Fletcher matter. As soon as Ms. Greenwood is done editing the document, we can proceed.
Thank you, Your Honor. Ms. Greenwood is in the document right now, should be done momentarily.
The document is here. She's editing. I'm not sure what she's editing since I haven't actually rolled yet. And in fact, it's the wrong document. It's a notice of hearing. I need a pretrial order so that I can determine bail. Would you like to upload that order?
Your Honor, I believe the pretrial form is now in Oak Court.
All right. Mr. Pope, are you available for an in-person review hearing at the Bothell Municipal Court on September 4th?
September 4th, that's a Wednesday, Your Honor.
Correct.
I can do that date.
All right, then I am going to set this matter to September 4th at 2:30 at the Bothell Municipal Court in person. Your client must appear, and I will indicate. Obviously, if she has either completed the community service hours or taken care of her other financial obligations, she'll be in a much better position to argue, but that goes without saying. I have signed that order releasing her to that date. Please make sure your client is there as well. All right?
I thank you, Your Honor.
Have a good day. Now, back to the in custody matters. Mr. Jensen.
Thank you, Your Honor. I think the last person transported today is Mr. Miller. He's ready to go forward with his arraignment. I can
Right.
do the colloquy if the court wants.
That's fine. Mr. Jensen, go ahead.
Mr. Miller, can you tell the court your true name?
My name is Stephen Ray Miller.
Earlier, you don't have to tell your birth date. That's okay. Thank you, sir. Earlier today, did I have an opportunity to read your constitutional rights to you?
Yes, you did.
Did you understand those rights?
Yes.
And earlier today, did I explain the charge that's been filed against you and the potential penalties?
Yes.
Did you understand the charge and penalties?
Yes.
Your Honor, we'd like to waive formal reading and enter a plea of not guilty.
Not guilty plea will enter. I was looking, I don't see that Mr. Miller has requested court-appointed counsel. Is that correct?
Well, Your Honor, we wanted to go through the arraignment and see if the court would release him the day he was released on his other hope that he could fill out the form and before his next court date was released.
All right.
But I'm prepared to assist him with the arraignment.
All right, thank you. I'm sorry, you did go over with him that he understands the maximum and minimum possible penalty or maximum possible penalties associated with this offense. Is that correct?
Your Honor, that's right.
Okay. Mr. Miller, I not guilty plea will enter. Court has previously reviewed the police reports, did make findings of probable cause. What is the city's request with regard to release and conditions?
Your Honor, at this time, the city is requesting bail in the amount of $1,000. Mr. Miller does have 20 lifetime FTAs, with 8 of those in 2019. In terms of conditions, the city is requesting standard conditions, an abstain condition, and a SOTA order.
Mr. Jensen.
Your Honor, I asked the court to look a little closer. As the city pointed out, a number of those warrants are quite old. I can tell the court that he recently was released on his other most recent outstanding issue on his personal recognizance out of Everett with his DUI case. He has standard conditions there, including absence clauses. So he has absolutely no objection to maintaining abstinence. I did verify his address in Woodville with his sister. That's on his rights page. That is correct. We did change and update his telephone number to his new phone number. So the court has that as well. So he'll be in Woodville. He has no objection to following the SOTA order. He has no reason for work or treatment or any reason to be in Bothell except for court. So he can follow all of the restrictions for the SOTA order. He's asking the court to consider his release on his own personal recognizance, Your Honor. I believe that with the least restrictive means, with the SOTA order, with him living close proximity to the court, he can return and be released today. That's our hope.
All right. I was concerned because I was looking at the date of the violation, but it looks like the prosecutor's office in Snohomish County, give me just a moment here, on that South District Court matter, waited to almost the last day of the statute of limitations to file.
That's true, Your Honor. And I know that can be extremely, it's hard for people to follow that when it's initially not filed and then a period of time goes by. So for the lay people, it's not always clear that they have something to deal with. So he does now, and he will be in court.
Well, it's interesting because he also contacted the court and said he was not able to attend because he was at work in Oregon, and they continued it one time, but then issued a warrant at 2 weeks later. All right.
I think he's
So
been in
that's how that
jail.
warrant came about. And so that seems, given that the city took, or the county took that long to charge, I think the court could have realized where he possibly was. We'll put it that way. All right, Mr. Miller, given that, and given the fact that you did reach out to the court and tried to let them know where you were in South District Court, I'm going to release you on your personal recognizance. I'm going to believe that you are going to appear for my court hearings. All right.
Yes.
I will release you. We're going to set this matter. Oh, let me tell you the conditions. Sorry. I'll release you on the following conditions. You need to notify the court in person or in writing of any change of address, have no new criminal law violations for which there's probable cause, only use your true legal name and date of birth if contacted by law enforcement, make an appointment with your attorney and make it to that appointment because they can't help you if you're not talking to them, right?
Right.
Make it to your court dates. Did I already say that? Do not, and give me just a second here. Do not possess, consume, or have under your control any alcoholic beverages, controlled substances, marijuana, or any of its derivatives, or drug paraphernalia without a validly issued prescription in your name. You will abide by a stay out of drug area order, which Mr. Jensen indicates he's already gone over with you. And I'm just going to reiterate what he said. If you do need to be able to go to any of those areas, you need to get a hold of your attorney, whomever that's going to be, and let them know that you need to go so that they can make a motion to the court to give you permission. Without that permission, being there, no matter how legitimate your reason is granted for law enforcement to contact you and potentially arrest you. Okay?
All right.
All right. So with that, I'm going to set this for pre-trial. Madam Clerk, do we have particular dates we're using right now?
October 10th.
October 10th?
Yes, Sharon, that would be an in-person.
All right. So October 10th at 1:30 in the afternoon, in person at the Bothell Municipal Court. Any reason that you cannot appear in person?
No,
Okay. So I'll see you in person at the Bothell Municipal Court at 1:30 in the afternoon on the 10th of October. Your
you
trial,
will see me.
what was that?
You will see me.
Perfect. And your trial's going to be in the November trial term, but your next court date is going to be
Your Honor,
October. I'm sorry. Yes.
my apologies. I was 1 month ahead. Can we actually set that for September 12th or the 26th?
I thought that that would be a better time. All
I
right.
apologize.
That's okay, because I wanted to set it in the October trial term because November is pretty tight there with time for
Yes.
trial. All right. All right. So would you like the 12th, or how about we set the 26th of September at 2:30? That's not a super crowded calendar. Does that work?
Me?
Yeah,
It's September what now?
26th.
Yeah, that's fine.
Okay, and that'll be in person at the court again. And this time your trial then would be in the October trial term, which is it's a better timing. All right,
Okay, so September 26th, at what time?
at 2:30 in the afternoon at the
Right
court,
here, right?
right here at the court. Yep.
Good.
All right. So we'll see you then. But you will be getting out today. Oops.
Right.
All
Thanks,
right.
attorney.
You're welcome. Good luck, sir. Don't forget to show up. See you in September.
All right.
Be safe, be well, sleep sweet, and much love.